Welcome to another edition of the Litigation Psychology Podcast brought to you by Courtroom Sciences. I am Dr. Bill Kanasky. Exciting episode today. A good friend and someone I've worked with quite recently, who I think is just a fantastic defense attorney, and his name is Chris Turney. He is the boss over at Turney LG Midwest Litigation in Kansas City, Missouri. Chris, how are you today?
I'm fabulous, Bill. So good to hear your voice and see you on the screen at the same time.
And by the way, if you're I think most people listen to this, but if you like to go to the CSI YouTube channel, you can see Chris's haircut, which I'm going to give a double thumbs up. Looking sharp, man. Looking sharp.
Man, you got to keep it clean, buddy.
Not everybody can pull it off. It's the shape of the head, and that's what you got, right? If you got that square block head, it doesn't work. And you know the guys I'm talking about. And sunscreen very important for the dome
Very
come summertime. So you're based in Kansas City. I have to pick on you immediately because I gotta tell you, for a long time I was fine with the Chiefs, and I see your little Chiefs sign in the background for people that can't see. It's right there. And so just a couple of things on the Chiefs. Number one, the Kansas City Chiefs fans have just become just unbearable. They're just intolerable. And they're turning into like the Patriots fans were, right? Back in the heyday.
no.
I'm sorry, they're just they won't shut up. And listen, they have bragging rights. And Chris, I was fine with it. I was fine with it until Taylor Swift got involved. And now the hatred is just coming out of my pores. You had it going good. Everything was fine. You brought her into this mix. I gotta tell you, it's a huge turnoff, Chris.
Well, she wasn't popular until she became a Chiefs fan.
I beg to differ. Object. I'm going to object. I'm going to object to that statement right there as argumentative. But yeah. So now I know in Vegas during the Super Bowl they had like you could bet on how many times they showed her or mentioned her name. That's how entrenched she is into the Chiefs system.
Well, it's a great system to be entrenched in, and I will defend myself. I was a season ticket holder before Mahomes ever parked himself here. So
Hey,
I suffered through the era that a
you,
lot of teams are suffering through right now. So hang in there, and whenever you get there, celebrate. It's not going to last all the time. It's not going to last forever, and enjoy it while you got it.
Well, Bears fans like me have been waiting since 1985. I'm just going to leave that alone. We're not going to. There's zero follow-up comments or questions
Well,
on
wasn't it
that.
2000? Was it 2009? You guys made an appearance.
The 2006, and they got waxed by Peyton Manning in Indianapolis. So again, another reason why I just don't want to talk about that. Moving right along. Now you and I worked with the witness recently. We covered a lot of reptile slash edge theory, and I was thinking about this whole safety is the top priority, right? Listen, Kansas City this last playoff season, they played a game in like 30 below zero, had every opportunity to push this game into the next day so it was safer for the fans and the players, by the way, Chris, and they did not. They played the game, and I just read an article yesterday that many of those like crazy idiots that were taking off their shirts for the cameras at 30 below zero are now getting toes and fingers amputated from the frostbite they've suffered. So it's obvious that over at Arrowhead Stadium, safety is not the top priority. I would like your response to that.
I have all of my digits, and I was there. So I'm just
Did you
saying.
take your shirt off?
No, I did wear a t-shirt right before the game for a quick 30-second picture, wearing my shorts, Crocs, and a t-shirt.
Oh, you're crazy.
Quickly jumped back in the car, shivering, and the picture didn't turn out all that great, but we didn't have time for a retake in that temperature.
That was unnecessarily and unreasonably dangerous conditions. I'm just gonna leave it at that. The jury is out on that. And some amputated fingers and toes from Kansas City fans. So I had to go
On that
rectal
note,
on there.
quickly, Bill, I'll just throw in there. I did buy a beverage before the game started.
How'd that work out
I
for you?
went to take a sip about halfway through the first quarter, and only a quarter of it was gone, and the rest of it was undrinkable. It was a solid block of ice.
I watched that game, and it just it just looked ridiculous. And yeah. Anyway, so we'll see how this off season goes and see because now we're gonna be in the dog days of summer and like we're just gonna be dying to have football here soon. But it's we got a lot of work. We got a lot of work to do between them. Chris, give us a nice introduction to your firm based in Kansas City and the types of cases that you guys handle.
Oh, yeah, thank you. So we're a small firm in Kansas City. I kind of call it the couple of P's. We represent professionals who, use reasonable judgment, although sometimes imperfect. We represent product manufacturers who push to innovate and improve our society. We also protect the medical community from hindsight bias so they can focus on helping us. Those are the primary cases we handle. Usually we are asked to handle the cases that have a little bit more of a technical side, being able to explain the science reasonably and in a world where the people can really understand it and apply it to the day-to-day basis. In other words, why does it matter? And why do we defend these cases?
Yeah, explaining science is always tricky, but I find that to be a unique combo of types of cases you handle by I think that's actually important. What I have learned in this industry, working in different areas of litigation, is I can take something from a products case and use it in medmal, right? And I can take something from medmal and use it in trucking, and take something from trucking. So there's a lot of things that you can learn from having that diversity of work. Do you find that to be the same with you guys?
Absolutely, absolutely right. And with professional liability, we do some engineer liability cases. And that translates really well into product liability. And then, of course, with the injuries that you sometimes see in the product liability, it goes right into the medical liability. It's a lot of fun. It really is.
Yeah, absolutely. So, Chris, I ask every guest attorney gets this question: at what point in your life did you figure out, yeah, I really want to be a trial attorney? And I find that some of our guests, there were it was maybe a plan B, if not a plan C or D. Maybe they wanted to do something else first. What was your pathway?
Well, I did better on the LSAT than I did on the business exam. Was it the
MCAT,
I can yeah, no, that's the
MCAT,
medical school one.
GMATs, GMATs,
GMAT. I did
GMATs.
better
There
on
you
the LSAT than the GMAT. I actually got into law school. And,
go.
that was a big help.
Yeah,
But no, when I started law school, I swore I would never be a trial attorney. For some reason, I
really.
had in my mind that's not the kind of guy I want to be. And then, look at me now,
Yeah.
a couple decades in. But really, what happened to me is, in law school, I got involved with mock trial. Really loved it. I love the art and the persuasion, being prepared, and it resonated with me.
Now, you've done some speaking here recently, and you and I had talked about this offline, where you had a recent presentation, I believe, for the social inflation task force, and you did a webinar talking about kind of how you see litigation, and you showed me this cool graphic, but I want you to verbally walk us through this, because litigation is quite complicated as you know, and everybody's fearing, a crazy verdict or just some absurd settlement. And, there's a lot of crossfire, there's a lot of moving parts. And I've never seen somebody organize it the way you did in that graphic you showed me. And I think helping our audience kind of understand how you see it and the different kind of quadrants and how you categorize things. Because some of this stuff, you can fully control, right? But other stuff you really can't control, and you got some internal factors and some external and some external factors. Can you kind of walk us through kind of your organization of those concepts and how you divide those up, and how does that help you kind of guide your practice?
You bet, Bill. I love the word you use, this concepts. You're an amazing scientist. You do a lot of research. You publish a lot of papers that I read. You have great guests on your podcast. You know a lot about this stuff, and
Do
I
you
learn.
really read the papers? Do you read do you
I
do?
absolutely do
Thank
because
you.
I mean I defend professionals. I have to know how to do this stuff, right?
That means a lot to me. Thank you.
And so, with this graphic that I created, it's more conceptual by nature. And again, it's kind of like what we do when we're representing doctors or, product manufacturers. We take this complex stuff and we try to put it in everyday language so it's more understandable. And what I wanted to do with social inflation, because it's such a lightning rod topic now, you got people saying that it's all made up, right? And then you got people saying that it's because of this or it's because of that and it's because of this. I saw a guy post on LinkedIn the other day that, the reason for these verdicts is blank. And it was like a singular thing that he was talking about.
And I saw your
And
post on that. Yeah. Yeah.
yeah. The one time I actually interact. So,
Yeah.
but what I wanted to do is pull all of these things together and say, how does this make sense? And this is the way it makes sense to me. And I think in concept, it has made sense to other people. And what I did was I kind of broke it down into two kind of constructs that create a 4-square grid. And so let's say that on the left side of the line, you have direct actions. And those are things that I say are happening inside the courtroom. On the right side of that line, you have indirect actions, which are things that are happening outside of the courtroom. And these are contributors and drivers to social inflation. Then if you draw the horizontal line that creates the 4 squares, on the top line, above the line, you have intentional actions. So these are things that attorneys are doing to intentionally drive up the cost of settlement or verdicts. Then below that line, you have unintentional actions, which are things that we're doing and either we don't know it or we don't realize the impact they're having on the inflated settlements and verdicts. So what you have is these 4 grids. You have direct and intentional. So those are the things that the lawyers are intentionally doing inside the courtroom. Usually to rile up the jury or to threaten the jury, to empower the jury, these things that we hear about all the time
Mhm.
to try and drive this narrative that, hey, there's a systematic failure within this company that is a threat to society. Let's do something about it, right? And so those are things where you've published a lot about the reptile tactics, the cutting edge theory. We hear about the MOE, MOI, mechanism of injury, the mechanism of the incident. We have life care plan abuse. Those are all things that are intentionally being done inside the courtroom. And so those are intentional and direct. I feel like that's what gets most of the attention from the defense bar is kind of complaining about those
Yeah,
things.
I think that you're correct. I think some of it's pretty legitimate, but then when you talk to a plaintiff attorney or you listen to some of their podcasts, they'll certainly argue back that hey, we're just doing our job and we're fighting for justice and all that. But I certainly agree with you. Those are the things that get the vast majority of attention, yet only account for a proportion of what's going on.
For sure. And I'm going to actually be clear for a second. So I don't begrudge the plaintiffs bar for doing a very good job at what they do. There's a few tactics that I kind of think maybe, push a little bit too far. I'm not going to go
Sure.
into what those are now. It's just my 2 cents. But at the end of the day, here's the deal. They're officers of the court. They're a key part of the judicial system that we have in this country. So am I. And so I have a couple of options. I can sit back and whine about it, or I can sit there and figure out a way to do something about it
Yeah.
and get good results for my clients anyway. And so nothing that I'm saying right now is intended to be a slight to the esteemed colleagues on the other side of the V. Y'all doing a great job. I want to match that. I want to match that intensity. So
Yeah, I agree. So let's keep going through your matrix, 'cause this is
cool. So
really
we just
important. Yeah.
talked about the direct and intentional. These are things happening inside the courtroom intentionally. So let's move to the top right-hand quadrant, which I call the indirect intentional. So these are things that are going on outside of the courtroom that are intentionally being done to create this system in which there's some inflated verdicts and settlements. And a couple of examples on here, I call it verdict shaming. We see it on social media all the
Oh,
time.
it's every day now. Wow.
Yeah, insurance company B could have settled this for 250,000. We just whacked them for 2.5 million. And
Yep.
part of me is like, well, good for you. But I think a big part of what's going on there is with the shaming, that it creates this mindset in probably the defense lawyers as well as the companies or the insurance companies that, oh gosh, I don't want to be on the receiving end of that. I'm just going to pay more, right? And so I
Yeah.
call it verdict shaming. And this has some kind of a psychological impact on the defense side.
It absolutely does. And back to these like LinkedIn posts. By the way, they're like every day now. I'm seeing this verdict shaming, but kind of a subset here, which I want your feedback on. is I'm seeing a lot of we got this X million dollar verdict, and and in capital letters they will put on a zero offer case.
Hmm.
Now, when you read that, assuming that's true, yeah, it kind of makes you scratch your head a little bit, right? Like zero, like what's going on here? Because when you listen to and again, hats off to the plaintiffs bar. Neither you or nor I are criticizing them, but yeah, they have a lot of podcasts out there. They're very good podcasts, and one of the things that comes up persistently in the podcast is they will complain and saying, we would love to settle these cases reasonably. And the insurance companies are giving us zero goose egg or just something very insulting. And that's what's getting us all riled up. And that's why we want to go beat them so bad. What are your thoughts on that? Because I'm seeing more and more of those things being posted.
Well, I mean, it's the bottom line is what's reasonable. I
Yeah.
mean, that's what we argue about in trial all the time. What my opponents think is a reasonable settlement is nowhere in the ballpark, in my
Yeah.
mind. On some cases, obviously 90+% of my cases, we sit down and have some barbecue together and we get the deal done. I've gotten some serious cases resolved for what I think was a very fair settlement because I think there are lawyers who still work well together. I like to think that there are. Um,
You don't see that on LinkedIn though, right? Yeah, it's kind of like again, LinkedIn's getting a little Facebookish and Instagramish with some of the way the comments are out. But to work with your adversary to come to a reasonable settlement, and that happens, no one's going on no one's going on LinkedIn saying, "Hey, I just settled a case reasonably, and I worked with a pretty nice plaintiff attorney, and we got along great, and we actually were logical. We hammered out a deal." Like you're never going to read that on LinkedIn, but it does happen, right?
well, it happens more times than
Yeah,
not. And you're a scientist, you publish articles, you analyze articles. What is selection bias?
yeah,
That is when you
exactly.
select a certain group of people and think that's the norm. And
Yeah,
that's one problem. Like I love LinkedIn and I gain a lot from it. Um, but when we treat LinkedIn as the entire world, we are creating in ourselves a faulty way of thinking because of selection bias. We're only seeing those things that are posted about.
you're right.
And if we flip the shoe, and if the plaintiff's bar does what we do, and they see all of these defense lawyers saying, "Hey, we got a defense verdict, plaintiff left $400,000 on the table," they would start to get that in their
Yeah,
head too. And so I think selection bias is a big part of this verdict
true.
shaming that we talk about. And that's what I'm trying to commit, talk with my clients and the insurers about is, hey, we got to be careful making too many hard decisions based solely on what we're seeing out there. And same true
Absolutely.
with advertisements.
Yeah, yeah. Now, within this section of things going on outside the courtroom to drive up settlements and verdicts, are you seeing which I've seen for quite a long time, but I guess I've seen more of it, is the email from opposing counsel or phone call from opposing counsel saying you have until Friday to write a check for this much, and if not, it's going up by $100,000 every day until like some of those types of tactics as well.
Well, for sure, and I kinda call that bad faith abuse,
That's not good.
and that's gonna draw a lot of criticisms, and I get it.
That's
But I mean, I gotta tell you, a lot of the insurance companies I do some work for are super reasonable. They really are. It's
yeah,
just what is reasonable? And whenever the game becomes trying to create this rift between the insured and the insurer, the game becomes something besides what the injury actually was.
yeah,
And it's a different battle that we're not unaccustomed to, and we know how to handle that. I have, my own strategies, but that is a big part of what we face on the defense side. What
yeah,
I always wonder though is what happens to the plaintiff lawyers when they turn down a very reasonable offer from my client and they get poured out at trial. There's backlash there too
yeah,
that we don't get to
yeah,
see. And so we always have to keep that in mind too. There's a shoe on the other foot too with these things.
yeah. All right, so we have some, intentional things going on inside the courtroom, outside the courtroom. Now, what about the unintentional factors? Because I think this is very important.
Absolutely. So below the line are the unintentional things that lawyers are either doing without knowing what impact they're having, or the lawyers aren't doing it all, but others are doing it. That's the unintentional. And so direct is again in the courtroom. So unintentional direct behaviors that contribute to social inflation. For example, what your world is, what you're there to help us to protect against is
Yeah.
witness crumbling. You know, you
Yeah.
get the witness on the stand and the witness crumbles. And by the way, this is as true for plaintiffs as it is
Oh
defendants.
yeah,
There are
absolutely.
plaintiff lawyers who moan, you know, after their witness gets on the stand and just crumbles.
Yeah.
The pressure is it's great. Well, it's not something that the lawyer intended to have happen, but
Sure.
it's in the courtroom and it impacts. For the defendants, it's when our corporate representative or a bad employee or whatever gets on the stand and, you know, they just fall victim to all the things that you help lawyers to protect against. That has a direct impact. It's in the courtroom. And then another thing, this is a term that hit me the other day. I'm not going to trademark it or anything, but I call it spike valuations. It's something that I hear clients complain about with some of their attorneys across the country sometimes, where the attorney's beating their chest in discovery. Oh, we got to win. This is zero offer. This is zero offer. Or, you know, this is only $100,000 case. Then the courthouse steps get kind of wobbly when you
Yeah.
walk. It's in the
Yeah.
mind, right?
Yeah.
And when they get up to the courthouse steps and they're wobbling, they email their client, "Hey, we need to pay on this case. You know, this isn't good." Well, the clients hate that, of course.
Yeah.
They have a plan for that, and I call it a spike valuation. And what it is I believe it's a fear-based mindset. It's this threat, the same threat that is the basis of some of the reptile on edge theory happens with the defense lawyer too. They're walking up those steps and they're like, "Gosh, I don't want to lose." You know,
Yeah.
I,
Yeah.
and maybe they're not prepared enough. And sometimes I'm going to be really controversial.
That's
Maybe
all
the
right.
client hasn't let them prepare enough, right? And
Listen,
all of these things
yeah.
feed into the mind that they start second guessing themselves and they get the yips.
It's come up a lot, particularly after I give a speech at a seminar where either somebody will raise their hand and say this, or they approach me afterwards and they say like, I want this type of weaponry that you're talking about, but my client won't let me have it, and that puts me in a really tough position, which I do agree with. What approach do you take? Is kind of an aside question here. What approach do you take with your clients on a case where you're like, you know, I need some extra weaponry here because of the nature of the case, or I have a witness like you and I had with some significant, you know, maybe emotional issues or something where I need some extra help and it's going to cost money. I need to convince my client to help me help them. What's your philosophy and how do you go about that?
Yeah, I think the biggest issue, well, first off, I have to say I'm blessed with clients that trust me. And so, yeah, generally speaking, I have the relationship. If I call them
Yeah.
and say, this is one that we need, this kind of weaponry, the clients I tend to work with generally, you know, yield to me on that. Um, I don't overdo it. And I think that's one of those things too, you know,
Yeah.
I'm not lazy in terms of, gosh, I just want to hire someone to come in and handle this witness prep for me and I don't overuse that grace, so to speak.
Sure.
But the second thing that I think is very important, you know, as I have learned from my clients, you got to do it early. And whenever you get that case in, you should know in the first 30 days what the trajectory is going to be. All right, who's
Hmm.
your opponent? Is this someone who goes to the mat
Yeah.
regularly, or is this someone who's going to chicken out? You know, plaintiff attorneys get wobbly knees too, and you know, so you can kind of tell early in the case if this is the type of case that you're really going to need to pour in some resources.
Absolutely. Sticking with the courtroom unintentional, a topic I do a lot. I gave this speech, and I give this speech every couple weeks to many of law firms recently is a speech on storytelling and opening
Mm,
statements. And I see unintentional bad storytelling happening in courtrooms because I think that everybody, speaking of bias, we've talked about that, confirmation bias, right? Your brain plays tricks on you, and they're really powerful tricks. And you may think, hey, I know the right way to tell this story. And little do you know, you're actually telling it in a way that's actually putting yourself on trial because you're only you have a very narrow, it's hard to look at your own file So you have to understand, I work on almost a different case every day, right? Multiple cases a week. I have a couple cases that are more long term, but it's always like, it's always rotating and I'm getting a fresh look at everything. And then the attorneys I'm working with, they've had that file for 3, 4, sometimes 5 years.
Yes.
And I can see something they don't see. And can you talk about how your own brain can play tricks on you, and you may not have the right theme or story because you're a little tunnel visioned after looking at this file for multiple years.
Well, that's absolutely right. The other thing you're talking about with storytelling that I think is interesting is I think lawyers sometimes, and this is on both sides of the V. I've been against plaintiff lawyers who really weren't good storytellers. But the thing that I remember in trial is every time I open my mouth, there's a storyboard
Yeah.
that's being created. And so whenever a witness, especially an expert witness, you don't do this with every witness, but usually experts, the first question out of your mouth is not some gratuitous, well, hi, welcome to Kansas City. No, it's the first question out of your mouth is going to be the hardest question that witness is going to answer on the stand.
Yeah.
And same in a deposition. The first question in a deposition, especially with expert witnesses, has got to be the hard question that they know they can't answer
Yeah.
because that's a part of the story, right? They
Yeah.
can't prove their case. If that's not the first thing out of our mouth, like you said, we're telling a different story. And
Yeah.
so what you said is exactly right. And one last note on storytelling. I heard this the other day and I actually love it. I'd love your feedback on it.
Sure.
Um, every defense lawyers are notorious for saying simplify, 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 cut, 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 cut. There's some truth to that.
Are they?
But I heard a speaker, was that
Are they?
some,
I'm trying to get them to simplify. They don't want to simplify, but
yes.
that would be the better plan. Yes.
But here's the thought. Here's the pushback on that. I heard a speaker down in Miami a couple of months ago. He's a fabulous storyteller. And he said, the issue with generational differences is not attention span. It's lazy to say that millennials don't have an attention span or Gen Y doesn't have an attention span. That's lazy because these are the same people that will binge watch a Netflix show all weekend long. So the
Sure.
problem is not attention span, the problem is interest. And as lawyers, if we have a complicated case, I think, yes, simplification is important, but you can only simplify so much. The bottom line is you've
Sure.
got to make it interesting
Yeah.
all the way through.
Yeah. You need dopamine hits to be coming, right? Just like on
There's my
the TikTok.
scientific
There you go.
buddy.
See, that's yeah, it's real, and that's really what it is. So how do you make it interesting? So yeah, and that requires I think several iterations because rarely is your first couple cracks at that gonna work. And then what I see a lot of is I want to simplify. Like one part of the brain saying, I got to simplify because I can't give a hour, 15 minutes opening statement. Everybody's going to fall asleep. I won't keep the jury. I need to knock that down to 30 minutes. Then you get it down to 30 minutes. You're like, oh man, that's not nearly enough. I'm letting down my client. And like, there's this mental war going on in the attorney brain. And
Mhm.
that's where your head starts to play tricks on you. Because one part of your brain saying, I've got to have this complex story because it's a complex case. And remember, now this is what the plaintiff attorneys say, right? And this is what they say. They say the defense wants to make it complicated. Like that's one of their main defenses. But on the other hand, that doesn't really necessarily work all the time. That can backfire on you, right?
That's absolutely right.
So,
Yes.
all right. So we got the last quadrant, which I believe is unintentional outside courtroom.
Yes,
Am I close? Okay.
indirect being outside the
Yeah.
courtroom and unintentional meaning it's things we don't realize we're doing. And there's a list of things, and I think you're probably gonna share with at least some of the folks who email you this graph that I hand wrote out. Again, it's conceptual. This isn't like biblical.
Yeah.
I'm not trying to preach that this is the truth. This is just a way of thinking that I would encourage the listeners to actually contribute. Email Bill, email me
Yeah.
your thoughts. But in this world of unintentional and indirect, I feel like there's a few things in there that I'll just bring out now. And that's, we have a culture where speed of opinion matters. The first person to post something on social media is the most relevant, right? So we're kind of being conditioned to make up our minds fast, whether we're right or wrong.
Yes.
We have a very, it feels anyway, it feels like we have a divisive culture. because the things that are aired are the most, the biggest lightning rod issues of our era, right?
Yeah.
Because we're consistently bombarded with this conflict, this disrest.
Yeah.
And my guess is it sells for the media, but I mean, I've been neighbors with my closest neighbors the last 15 years. We don't agree on everything, but we still get along awfully well, right?
Yeah.
And so, but there's this culture, this idea anyway, that our culture is full of conflict. Um, and it kind of creates this sense of distrust that I think is important as we go into jury selection. Social media is a very important tool, I believe, for us. How vocal are these jurors about issues? Are they quick to
Yeah.
respond? Are they quick to react? How violently do they react? There's a
Yeah.
lot of important issues, especially going into election years. Every 4 years, these issues seem to rise even more somehow.
Yeah, the social media with now in many cases we will assist or we'll be asked, about I'll be given social media history from a potential juror during, jury consultation. And the issue with that is like you can't read too far into that, Chris. And here's why. Number one, people bullshit their way through social media, right? Trust me. I know, so I, of course I'm not going to say who it is. And I know they're a miserable human being. Okay. But if you go on their Facebook page right now, you would think they're just living it up and everything's great. So there's not a lot of honesty going on social media. And then number two, my favorite, because this happens on LinkedIn, is what I call the keyboard muscles.
Mm,
Keyboard muscles. So the people that may react, like you say, very intensely to a post, in person they're like a mouse because
mm.
they're cowards and they would, but on a keyboard, oh boy, they're powerful. And when you're face to face with other jurors, right, other jurors, oftentimes we do these mock trials and focus groups every week. Other jurors will hold you accountable if you're full of it, right? And so a lot of those people that may be very outspoken with the keyboard don't have what it takes to really influence the jury. So I'd say pay
Mm.
attention to that, but I wouldn't bet the farm on what you're seeing on social media from jurors.
No, very interesting. And I guess the thing that I use social media for myself is like, what are their internal drives, right? I mean, if they're
Yeah.
consistently commenting, on the political post, they're tied in, they're very opinionated about it. To me, anyway, and you would know way better than me, Bill, but to me, internally, that's their core. That's who they want to be. And like you said, whether they're that way in person or not, that's an important construct I've not thought about.
Yeah.
But internally, that's going to resonate. What they hear in the courtroom is going to resonate more with that part of them.
Yeah, absolutely. Let's shift gears. Let's talk about, and again, we'll just keep this generic. You and I did quite a bit of work recently with a witness, preparing that witness for a very important deposition. And again, we'll just keep this high level. This witness, and we've talked about this several times on the podcast before, and I tell everybody on this podcast, you've got to dig deep with your witnesses well before you start that preparation process to figure out how they tick, what's going on in their lives, how are they emotional responding to things. And this particular witness had a lot of outside things going on that were impacting his emotional status, and it was a huge challenge. And I want you to talk a little bit about that. Is when you figure out, okay, I have a witness that maybe is super anxious or super fearful or very high strung, and it's not just from the case. It's other things going on in their lives. Though again, we've talked about the laundry list of things. There's people that are, going through divorces. There are people that are going through bankruptcies. There are people that are caregiving for a sick parent. There are people that have special needs kids, and they have all these stresses on the outside life. And if you don't understand what's going on in your witnesses outside the litigation, what's going on with them, that can
Mm.
really come back to haunt you, right?
Oh, it absolutely does. And well, even if it doesn't haunt you, it limits what you can do
Yeah.
for them. And, a friend of mine used the phrase, get into the trenches with your clients. And that's exactly what we're talking about here. Back to your keyboard muscle,
Yeah.
comment.
Yeah.
If you're emailing your client, you have no clue. You don't get a peek into their soul. You don't get a peek into what internally drives them.
No.
Picking up the phone and calling them helps because you can kind of hear tone of voice, you can observe some of these things, be perceptive. In that particular case, my client actually authorized me to fly out of town to go visit with this person. Um, I did. I flew down for a weekend on this witness's turf,
Yeah.
and we broke bread together, as our friend Mike Bassett always says, break
Yeah.
bread with your client.
That's Bassett.
And it was during that bread breaking process that I learned an awful lot of stuff about what this witness was going through.
Yeah.
And oh my goodness, it just opened my eyes to we have a lot of work to do.
Yeah. And that would have, listen, that would have never happened in an email exchange, and maybe not even in a phone call.
Correct.
To really spend that more intimate time getting to know that person, getting to know them as a human being, not just a witness or a physician or a professional, right? Or an engineer, to really get to know them, to know what you're dealing with, because as you know all too well, uh, the deposition process can often be a very brutal process. It's a process that by nature is very stressful. It's a foreign process to most people. And if they have other things going on in their lives that are sucking away mental energy and piling on when it comes to things like anxiety, it's going to double, if not triple, the challenge that you face, right?
It absolutely will. And what's the one thing we really want from witnesses when we're preparing them? We want buy-in from
Yeah.
them. We want them to commit to the process. And I'm a big fan of studying the nonverbals. How am I behaving, and is it consistent with what I'm intending to convey?
Yeah.
If I don't even take the time to go visit my client in person,
Yeah.
am I conveying to that person that their buy-in is important?
Yeah.
If I'm not buying into them, are they going to buy into this case? And there's different levels of cases. I get it. There's a $5,000, $10,000 case. You're not going to fly across the country to visit with
Yeah.
that witness.
Sure.
But in any case with any teeth, my goodness, you got to get in the trenches with your client. Show them that you're buying into them. They will buy into you.
No, I totally agree, and I think it's a really wise move, and I just think it helps that kind of bonding and trust between you and your client. Shifting gears, you wrote me an email last week. You said, "Hey, I just listened to your podcast at broadcast when you were talking about personal questions, those kind of
Mhm.
background personal questions that are making witnesses really angry because they find them so intrusive." And you said you wanted to talk about that. This happens in every deposition, and the plaintiffs get the same questions.
They do.
But when I think when any witness gets those questions, I think everybody goes on the defensive really quickly. What do you think about those questions, and what is your how do you talk to your witnesses about those?
That's an important point, and it's good timing too, because I think this kind of fits into that unintentional, indirect
Yeah,
kind of thing, this anti-corporate sentiment in our society. And defense lawyers always talk, we want to personalize our corporate clients, and that's, I think, absolutely right. But in order to do that, they have to be able to talk about themselves as a person, as opposed to a building. I call it buildings and balance sheets, right? And so if we are wanting at trial to have this person talk about how they are a person and not a company, to me, there's a little bit of a trap if we're objecting to a whole lot of personal questions in their deposition. Now, there are limits. Well, tell
sure.
me about your divorce. How many kids did you have? What did you do to her? Those types of things are probably over the edge. But when I was listening to your podcast and we were talking about, the clients who don't want to talk about themselves, one thing that I think we need to be communicating to our corporate clients in particular is, look, I want you to be a person.
Yeah,
And if we're going to sit here and say that these personal questions are irrelevant, I worry a little bit, Bill, that it's a trap. I feel like the plaintiff's bar probably wants us to make that objection. Because if we make that
yeah,
objection in a deposition and we get this witness on the stand at trial, you know what we're going to hear? Wait, judge, no, 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 no.
yeah,
They said that's irrelevant. So just
yeah.
talk about, buildings and balance sheets. And so I'm always wanting to think a little bit ahead of, like, are my objections creating a trap for myself down the road I'm going to have to live with?
Yeah, that's a very interesting take. All right, one more professional question, then we can have some fun. And I still have to rant. We talked about this in our witness training of your client recently, and it's something I scream and yell about this every week, all week. I think and I know this scientifically at the jury level from a credibility standpoint, there's a massive difference between a witness owning their conduct and decisions versus a witness defending their conduct and decisions. And juries deeply respect and appreciate when a witness owns what they did, and even better, which is the tricky part, owning what they didn't do. And then on the other side of that coin, it makes jurors nuts when witnesses become defensive and they start defending and they start evading and they become argumentative and they're going, yeah, but it doesn't work. But that's that kind of amygdala hijack, fight or flight that you and I have talked about. Talk to me about that, and when you're talking to your clients, and the importance of owning conduct, and how you are the defense attorney. You will defend, and you have defense experts that can defend. Having your client going on the defensive is rarely, if ever, a good thing in my mind.
It is. It's a hard thing because when you're defensive, you're not always thinking through.
You're not.
And,
Fight or
and a
flight.
lot of the damage that's been done, embarrassingly on my watch by witnesses that I've produced, they come in those defensive modes where
Yeah,
they think they're helping themselves. And I'm like, you're talking yourself into a hole here. And by the way, you're not telling the truth, the whole truth, and nothing but the truth. If you're
exactly.
agreeing with this person on the other side of the table, you got to listen to what they're talking about. Um, and as far as that defending, versus owning, I think one of the key conversations we have to be having with our clients is, look, the standard is not perfection. That's
Yeah,
what they want you to think.
yeah,
They want you to think that just because you made a mistake, you breached the standard of care. And folks, that's not the truth. The standard is almost always reasonableness, and it's not perfection for a very good reason, because then all of us would get sued for everything we do every day. And
yeah,
so when you have that conversation with a client, what it does is it helps them to say, look, okay, I was imperfect on this thing and that thing, and I own that. And then when you're asking questions later on, you can get
mhm,
them to explain maybe their thought process of
yeah.
why. But when they're under attack and under
They're not
cross-examination,
going to be able. They can't do it.
right, what they have to do is be able to leave that door open for you to do it later. And that's where I think the art and the science match.
It's very tricky. It's very difficult to do, but I I despise the pivoting maneuver. That's a political maneuver. It doesn't work, and again, juries cannot stand it, and we can prove that. All right, now let's go to some fun questions, and then we're gonna wrap up here. First fun question. Okay, so you live in Kansas City. Are you a barbecue snob? Do you get into arguments with people from Texas, North Carolina, and Tennessee? And be honest.
I don't get into arguments because I've had good barbecue in all those places, but I've never had the excellent barbecue that we have here.
Okay, give it. Okay, so I know that you're giving. I'm not going to argue with you about Kansas City barbecue. Obviously, that's your number one ranking. But if you were on the road, what would be your number two ranking? Where would you
Oh,
want barbecue from?
there's a joint down in Austin, Texas, when I was in a
Ooh,
conference down there last
let's
year, and
go in
I
Texas.
just can't remember the name of the place. It's a guy's name, but it was fabulous barbecue. Like, it was really good. Yeah.
Okay, so we're going Texas number two.
Well, that's where I went to law school. I have to get Texas back.
Okay.
Yeah.
Well, our listeners from North Carolina, Tennessee, and Georgia, and some parts of Louisiana will not be happy with you, and so I'm sure I'll get some hate mail over that. But that's okay. This is part of doing a podcast. Not everybody's going to be happy. Second question: you and I are music junkies. We're Gen Xers. I'm gonna give you my three. Like if I go to the gym and I'm like, okay, 90s rock, right? And for an
Mm,
hour, I could just pick three bands to listen to where it's gonna get my blood flowing. I'm going ready for this. You ready? Okay.
okay.
I got Audio Slave.
That's
Chris
good.
Cornell, right? The Offspring. Yep,
Okay.
that'll get you going. And then Stone Temple Pilots.
Oh yeah.
What
Oh
do you
yeah.
think? What do you think about those? That's strong coming out of the gate there. Where are you at with this? And you may have some, we may have some overlap.
So here's my thing. I'm a music guy, but I like so many genres of music that I am not an expert on any of them. But I will say, when I'm listening to my old school Pandora that my kids and my associate
Yeah.
make fun of me about listening to, you know, when Bush comes on the
Oh,
Pandora station,
yeah.
it's a jolt. Every once in a
Which
while
is
they'll throw in,
fantastic.
yeah, every once in a while they'll throw, Metallica One in there.
Oh, oh,
That's like,
that'll.
you get the workout and then you get the rest,
Oh
both in the
yeah,
same song. It's pretty amazing.
I
But
like
then,
that.
the classic, and I've been criticized for this in the past, but Pearl Jam. I mean, that's a go-to.
They kicked it. Nirvana and Pearl Jam kicked it off about 1990. I remember I was just finishing up high school, and I put on the radio, and I said, oh my, what
Right.
is what? Like that's different. That's not Motley Crue. That's
Yeah.
not Metal. Like there's something
But
different there. And then
Pearl Jam's 10 albums starts off, because we're in the CD era. We can still name the tracks, right?
I still
Track
have the
one on,
CDs. I still
yeah,
have them.
track one is once, right? It's
Yeah.
like it starts off strong, and then track two is even flow, and then you're just done from there.
Yeah.
Yeah.
It's really, really incredible. Well, thanks for coming. I'm just gonna share this rant with you and you can comment on it. Okay. And this is a rant that I just want the whole audience to listen to. And I've said this like no less than 25 times. Apparently no one listens to me. Okay. If your trial is next week, do not call me 5 days before your trial asking for help. Are you out of your mind? Like, do you think I'm just like, oh yeah, I'm free next week? No, no, I just don't understand what what's going through your head. At what point did you figure out what, I got a trial in 5 days. Maybe I should get my witness ready, or maybe, yeah, I mean, it's really making me nuts. I had 2 calls last week. Ask me what I was doing Monday and Tuesday. I'm like, well, I'm busy, but like you have a trial next week. People, if you and so here, I'm going to turn this over to you, Chris. This is important. You've got to be proactive with your cases, and if you're doing things last minute, you're probably not doing things correctly, right? I,
Well, there's truth in that. I will say I'm one of those guys, my best ideas hit me late in the game. But what you have to do is you have to prepare for that.
yeah.
And so what you do is you work up the case with all the contingencies out there. And, back to the football analogy, I mean, you brazenly compared my Chiefs to the Patriots. But back to that football analogy, it's fourth and goal on the 1 foot line, and you can go for the tie or you can go for the win. The coaches will always say they don't make that decision in 45 seconds on the play clock. They make that decision back in August at training camp.
Yeah,
And
they knew this was coming. They
that's
knew
how
this
we
was
have to
coming.
think about trials. And when you have that case that's on your radar, they're like, dude, this one's got a good chance of swinging. You got to get ready. And
Yeah,
even though your best ideas can hit later, and Bill can certainly help with that, right? But you got to
yeah.
get Bill involved earlier, because there's no local rule that says Bill Kanasky gets to rewrite the deposition answer. You
No,
know, not yet,
no,
not yet. We'll
not
push for
yet.
that.
Yeah, I don't think I don't think it's that. But yeah, I think the days of, because what I see here is I'll call you if the case doesn't settle, and my
Mm.
response to that is that could be too late. That could be too late. I think you need to plan on that. And if you're starting your trial prep only when the case fails to settle, I think your adversary is probably way ahead of you. Would you agree with that?
Oh, that's absolutely right. When you listen to the plaintiff lawyers talk, they've tried their case before they file it. If
Yeah,
you listen to, if all
they
of them
have
are
to.
being honest, that's what they
Yeah,
say.
yeah, yeah. They've got to pick the ones that they believe in, the ones they're going to spend their time and money on. And then I do think that the defense could be far more aggressive early. And those are the clients. Sounds like you have clients like that, and those are the clients that I like to be affiliated with, that are proactive and aggressive early. Well, Chris, thank you so much for being on the podcast. I know you're an avid listener, and I appreciate that. Best wishes here over the summer months, and absolutely keep in touch and let me know if you need anything. But I'm really, really happy to have you on, because I think the way that you talked through those different quadrants in your matrix are a really good way to conceptualize kind of what's going on in litigation and what's under your control, not control, courtroom, outside of courtroom. I think that's a really nice breakdown.
Appreciate that, Bill. Appreciate you.
I appreciate that. And to our audience, as always, thank you for listening to this edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences. We will see you next time.